and Prime Minister of India and the Prime Minister of Bangladesh that they would take back post 25 March 1971. Now, what would you do? These were not illegal. They couldn't be pushed out of Indian territory as illegal immigrants.
So extend the time and give them more time to get
Therefore,
themselves registered.
Therefore, the tacit understanding was that they would remain in India. You couldn't push them out back to Bangladesh because that was not the obligation which was assumed by Bangladesh. Therefore, instead of maintaining them as stateless persons in India, at least bring them into the mainstream by conferring the citizenship on them.
Just, my lord, as a proposition of law doesn't arise here.
Political compromise.
Doesn't arise here, my lord.
That's 71. Post 1971, there's no question of 6A doesn't.
Even Bangladesh agreeing to take them back,
yes,
not agreeing to take them back.
They don't have. They don't even.
They agree to take them back.
They agree to take them back.
Post 71.
Yes.
Post the cutoff.
And they don't even come into the zone of citizenship.
That's correct.
Yes. So they are illegal immigrants.
That's correct.
And therefore, at some point, we'd like to know from the government what is the government doing in respect of those persons, because their grievance
That
in regard
is
to
something,
those.
my lord, a really serious issue. We have said, my lord, what we are doing, but something more is required to be done. Because there is, my lord, demographic change, and my lord, there are several problems, my lord. Therefore, I started by saying that their concerns, their problems are not, my lord, I am not trivializing. I'm saying they are correct problems. I am only defending 6A, that's all. This limited period.
The communication, the Honorable Prime Minister of Bangladesh also acknowledges the fact
Yes.
that there are scores of others who entered illegally thereafter.
Lord, whenever they say,
Solemn undertaking what they would be taken back.
no, whenever Bangladesh, the sovereign of Bangladesh says that before 25th March 71, we will take them back, it implicitly gives an assurance that after that, nobody will be permitted to cross over. That's how, Lord, the international relations operate.
Also, Mr. Solicitor, there's one other dimension that pre-25 March 1971 would comprise of two groups. People who have been granted citizenship, everybody before 66 becomes a citizen, right? After 1166, everybody qualifies for being considered for the grant of citizenship, provided conditions are met. Those who are granted citizenship would become a part of our mainstream. Those who are not granted citizenship, you can't push them out anyway, because Bangladesh is not going to take them back.
Then, my lord, it's not necessary for them. Their agreement is not necessary. If they are not granted citizenship, it would not be possible. That contingency may not arise, because if he is unable to show that he is a foreigner, my lord, he is a citizen of India. But if suppose somebody suspects that so-and-so is a Bangladeshi, I go to the foreigners tribunal and say, no, you are not a foreigner. That means I am a citizen of India. If I am a foreigner, before 71, I'll get the protection of 6A. And if I am declared a foreigner after 25th March 71, then I'll have to be, my lord, as per law, pushed back to Bangladesh.
Point.
My lord, please now come to, my lord, some facts and figures. Volume 3, my lord, the affidavit filed by State of Assam, it starts at page 969. My lord, there are several affidavits filed. My apologies. My lord, this is the affidavit dated 5th December 2014, page 969, volume 3. But there are several affidavits filed by both Assam, state of Assam, and the central government, but I am not troubling your lordships with other contents, my lord, which are not 969. Affidavit dated 5th December
Joydeep
2014.
Shukla.
Six nine six, 969. So the relevant part would be page 982. I'm not going to read anything, my lord. I'm just giving the details which were placed before your lordships. And whatever is relevant for the present purpose and whatever may answer my lord's very pertinent queries, my lord, I'll show. Because affidavits are very long affidavits, etc. My lord. My lord, now please see page 982. Your lordship gets, my lord, page 982. Number of cases, my lord, Chief Justice goes. Number of cases before the Foreigners Tribunal and their disposals. The details of cases pertaining to January 166 to March 2471 referred to the Foreigners Tribunal between 86 to 31st July 2014. Because this affidavit is filed in December 14. The figures are as on that date. Total number of
which volume?
inquiries.
Volume 3.
3.
I'm
sorry.
Page,
No, no.
PDF page 982.
PDF page, my lord, is 982.
Yes.
There is a chart, my lord, Justice Sundaresh. my lord,
Yes,
may
I
get.
get. Yes.
There is a hazy chart, my lord. It's a scanning of a Xerox, my lord, possibly. That's why it's hazy.
Yes.
Total number of inquiries initiated for period relating to January 66 to March 71. 52 lakhs. 5 lakh 20. Yeah, 5 lakhs 20,438. Number of inquiries completed 5,22,326. Number of cases referred to the Foreigners Tribunal
42,000. Number of cases disposed of by the tribunals 31,105. Number of persons declared foreigners for period relating to January 166 to March 24, 32,969. Number of persons whose names were sent for deletion from the electoral rolls, the same number. My lord, your lordship knows they are disenfranchised from the date of the declaration. Total number of persons registered with the registering authorities, 13,914. Total number of persons declared as bona fide Indian citizens for period relating to January 166 to March 24, 71, 27,078. Total number of
Got citizenship as of the date of this affidavit is about 27,000.
So, yes.
And
Total
11,000 cases are pending.
11,000 cases are pending. And details of cases pertaining to, well, the difficulty is
71 and 8.
What about
that is next. That is next. My lord. That is, my lord, alarming, and next chart is not covered by 6A.
tribunals functioning?
Date on which it was inserted and came into force?
7 December
I just
1985. 7/12/1985.
Ah. That is why they have taken.
7/12/85 minutes.
That is from 86 onwards.
Yes. Now, my lord, the second chart, my lord, is little alarming. Details of cases pertaining to the period from March 2571 referred to the IMD tribunal. My lord, there were earlier,
There were tribunals, some tribunals were there.
there was IMD tribunal, my lord, which was set aside in Sonowal judgment, with which your lordships are not concerned, but there was a tribunal. To IMD tribunal and subsequently transferred to Foreigners Tribunal after scrapping of IMDT Act. Plus, scrapping means it was declared unconstitutional between 83 to July 31, 2014.
Total number of inquiries initiated on or after March 25, 71, 76 lakh 7, I'm sorry, 7 lakh 67,927. Then two, number of inquiries completed under IMD Act and total 7 lakhs 44,820. Number of cases referred to IMD tribunal or Foreigners Tribunal 41,000,
4,19,258. Number of cases disposed of by the IMD Tribunal or Foreigners Tribunal 1,87,294. Number of persons declared foreigners, illegal immigrants on or after March 25, 71, 35,000. Number of persons whose names were sent for deletion from electoral rolls 35,969. Then total number of persons declared as bona fide Indian citizens on or after March 25, 1971, 64,594. Lord, I just clarify this. Lord, they may be falling within 6A, but their decision comes late. Foreigners Tribunal, my lord, took decision late, or there may be a challenge before the High Court, Supreme Court, remand, etc., etc. The total number of cases where alleged persons are not traceable, that is 53,000. Because they enter from Assam and, my lord, spread all over. Mr. Diwan was, my lord, that's why pointing out that they have settled in Delhi. Some of them have, my lord, gone as back as far as, my lord, Jammu and Kashmir, etc. Then total number of persons deported, 2,447. Total number of cases pending before the tribunals, 2,31,000. This needs to be, now subsequent affidavit says that we have increased the number of tribunals, etc. But something more definitely needs to be done. I will not defend the undefendable. Now, your lordships may, my lord, come to the center's affidavit dated 5th December 14.
This affidavit of Joydeep Shukla is of what date?
5th December 2014.
Earlier one, which you showed us, right? Earlier one, the previous
Earlier,
one.
that both are of the same date. 5th December 2014, and center's affidavit is
5th December 2014. Where do we get that? Same volume, 1182, PDF page 1182. I'll just glance, your lordships, take your lordships through, just glancing.
Just, my lord, see the heading, my lord, that's all. Action plan for detection and deportation of illegal migrants in Assam and effective guarding of India-Bangladesh border. Then detection of illegal migrants. Procedure for detection of pre-71. So it's substantially the same we have pointed out. Procedure for detection, I'm going fast, my lord, so that it's not
necessary, my lord, therefore. Procedure for detection post-71, my lord, there are, my lord, what is the procedure put in place? Then deportation of declared illegal migrants, then strengthening of foreign tribunals. That your lordships would find at 1185. My lord Justice Sundaresh. Then, my lord, next page, detection of names of declared illegal migrants from the, deletion of names of declared illegal migrants from electoral rolls. Then, my lord, National Register of Citizenship in Assam. then effective border guarding for check and control of illegal immigration. It's a porous border. Now, my lord, fencing is done, there is guarding, there is, my lord, light shades, my lord, so that infiltration still continues, my lord, which is sought to be prevented. My lord, rest, my lord, is the steps which we have taken, my lord, to ensure that there is less infiltration.
This
But I would-
this data is of 2014. What is the present situation? How many matters are pending before the foreigners tribunals?
my lord,
We need that from the state of Assam. The Advocate General can give us up-to-date data. So that will indicate 2,13,000 cases were pending in 2,31,000 in 2014. What is the progress? How many have been disposed of? What is the action which we are taking? Because now post 71, 6A constitutional validity is one aspect.
yes, yes.
But Mr. Solicitor, as you also say, what Mr. Diwan has argued, what Mr. K.N. Chaudhary has argued, and Mr. Ansaria, you are also not denying the gravity of the problem as it exists.
It is a serious problem.
So
Serious.
we want to know from the government of India, what are we doing now? Because this is not just about changing the demographics of Assam. That's one aspect, the cultural aspect which Mr. Diwan highlighted, but also the burden on the existing resources.
Sources, my lord, those who should go to Indian citizens are, my lord, now being unauthorizedly shared by someone who comes only to share the resources.
People go from here to Mumbai.
Works because the affidavit says it is to be complete.
That also, my lord, as latest fencing work till date. There is one affidavit of 2018, my lord, but latest
People got citizenship in the pre-1166 category. How many people have got citizenship, say, with the cutoff date as 1166? How many people have got citizenship 1166-25-371? And the third period is post 25-371.
when question of citizenship doesn't.
That doesn't arise at all.
I'll
Because post 25-371, government has to be extremely serious about what is happening on the ground.
yes.
They may succeed on their constitutional challenge, they may not succeed, but
This
what they
is
are
a serious problem.
what they are saying has a great deal of substance, not only in relation to Assam, but for the rest of the country as well.
Because, Lord, they are not coming here because they are persecuted or there is some problem.
Yes.
Second.
$1193 million.
Of how many people have entered post 25 March 1971,
Approximately.
approximately. Because do we have any estimate of that in India? Two, how many matters are pending as we post to the Advocate General? How many matters are pending before the
Tribunals.
tribunal? How many tribunals do we have? Because frankly, we will deal with the issue of constitutional validity.
Which is something which we have to consider. I mean, that's a very weighty argument. But assuming everything that we affirm the validity of 6A, what are we doing post 1971?
As a matter of fact,
One other aspect which you may consider. See, our point also is that the very problems which the Solicitor General is projecting also happen in the context of Bengal, West Bengal.
We are going to come there. We come to that. Also, when you're answering now, I think we've understood the broad lay of the matter. What we'd now like to know from you is the Article 14 argument, the cultural impact, etc. We'll hear you very briefly. But your point really will be that, look, this was basically political policy. And therefore, this is something which is factored in. But we'd like to hear you on that.
I'll just-
But most important, why did you single out Assam when we found yesterday that West Bengal shares a much larger border with Bangladesh? And therefore, presumably, the extent of illegal migration into West Bengal would be as or even more significant. Or did we have any cogent data to indicate that the extent of illegal migration into West Bengal was minimal as compared to this? Therefore, we left it alone.
No, my lord, we don't have. And this is the answer which I am going to give, my lord.
Now, what my lord is saying is that now, after Assam, this illegal immigrant will get into more and more they get into West Bengal now.
absolutely.
What is going to see? Therefore,
It's
we want to
going
know
on.
how do you propose to deal with this? At least after 71, after 71.
And Mr. Solicitor, there are a couple of, we have to look at it at different layers. First, there is a layer of legality, that we deal with these illegal immigrants who are here with due process of law, because we are not some authoritarian country that you just pick them up and treat them, and use show the
The
power
due
of
process
the-
is the tribunal.
We have to follow process of law because we are a democratic country governed by the rule of law.
Correct.
And there's a grave danger that you might actually pick up, if you don't follow the rule of law, genuine people may be picked up and thrown out. That's something we must also.
Yes, sir.
But more important than also, what are we doing from here
Onwards.
for the future? What is the government of India doing in terms of ensuring that you have an impermeable border? How much investment is the government of India taking into ensuring that the border becomes, in that sense, impermeable?
Lord, I understand.
What are the executive steps which the government of India is taking? Have we, to what extent has the border been fenced? We understand that parts of the terrain is impossible to be fenced also, but what are the steps we want to know? Because this is a crucial problem, independent of 6A.
1126, my lord, may give some answer, my lord.
But this is again as of 2014. This is regarding border fencing, my lord, Justice Suryakant's query, my lord. My lord, apropos, my lord, yes, my lord, that is given, my lord, in the affidavit. My lord. Yes, my lord. What is the process? What is the procedure followed? That is undertaken, my lord. That is undertaken. They are being subjected to the foreigners tribunal jurisdiction. Data, my lord, we will provide.
as government of India, does government of India have data? And Mr. Solicitor, we understand the problems of all this as well. Because culturally, you're dealing with people who look exactly like you, they speak the same language, they dress the same way.
No,
What is the data with the government? What is the extent of the illegal immigration post 71?
my lord, I'll just, my lord, point out,
Do we have that data?
no, this is my answer, my lord, not the government's answer, my lord, because I could not, my lord, get it from the record.
So far as Bengal is concerned, well, the general discussion which I have with the officials is that Assam faced the problem and raised it at a level for the simple reason that culturally, Bangladeshis and Assamese were so different that it was easy to identify. In case of Bangladesh, their language, their food habits, their dressing, everything, they mingle very easily, number one. Number two, because of that, maybe there is no uproar or something, but that does not justify the government not taking steps. I must admit.
Correct. With great respect to my learned friend, regarding races, there are a lot of differences. One can make out.
Between?
Not predominantly Assam is a.
No, he is agreeing with you. He's saying
I'm supporting
Bengal. He's talking about Bengal, not Assam.
I'm talking about Bengal.
Bengal. That's why I thought I'll clarify. I got your point. We realized what was in your mind. He was talking about Bengal. But now tell us, what have we...
What I'll do is,
One way, Mr. Solicitor, their argument is strike it down under 14. You didn't do to West Bengal what you have done to Assam. You have an equal illegal immigration into West Bengal. You've just let it be. Let it be in the sense they are liable to be deported. You're granting them legality in Assam. One is the 14 argument. But beyond that now, we are going beyond the validity argument.
correct.
What are we doing? Why? First, we want to know what was the reason which prompted Parliament to exclude West Bengal from the grant of citizenship? We are not saying that they should have granted it. But why? What is it that led us to believe that this problem was peculiar to Assam and not to... Argument could not have been from the Indian perspective that there was an agitation in Assam.
Cannot, that can't be
The
there.
argument from the Indian
Can
perspective is
figure
we have to
can't
do
be
what is good for the
justified.
nation,
Yes, sir.
right? Why did we leave West Bengal alone? Second, what is the extent of illegal migration between 1971 onwards, and what is the position as West Bengal? And what is the government doing in West Bengal now?
I must admit, Lord, right now, my lord, my preparation was on the validity part and legal part, but matter may not end today.
So we'd like...
Undertake to file an affidavit of the authorized officer, Lord, latest by tomorrow or day after, on all questions, because
And we would like an updated statement from Government of India. Let the Home Secretary also apply his mind to this.
yes.
What is the Government of India doing in terms of safeguarding the border, in terms of border fencing? What is the updated position? How far has the border fencing arisen? Because this is also crucial in the sense of, we get all these matters which come up before us every day about, the...
Foreigners Tribunals Award.
No, about the people seeking bail because they've been, when they've been caught, cattle smuggling, so-called cattle smuggling, involvement with we've also had cases, you will recall, of our own paramilitary forces officers being involved with that.
Yes.
Those people have been proceeded against.
Yes, sir.
So all this is a very serious
Well,
problem.
my lord, I undertake that Home Secretary will file an affidavit.
All a party to these proceedings.
I think all states
All
are part.
states are right. You're a,
Well, state of Tripura also has equally the same problem.
but
In fact, Tripura it is
one second, we will come to Tripura in a moment. Who's appearing for the state of West Bengal?
State is a party.
Have they filed an affidavit?
But
Have they
all
filed-
states are parties.
Mr. Diwan,
One of
Mr.
them.
Chaudhary, has West Bengal filed an affidavit in this proceeding?
I just check.
That is going to be a problem.
State is a party, my lord. But I will, my lord, I assure your lordships, the Home Secretary will file an affidavit on all these concerns.
We would like to
Reason
have
is
an
this.
affidavit from them also.
The
From the state of West Bengal also, their official stand we want to know.
Certainly, my lord. The reason is this, my lord. Forget, my lord, anything else. Your lordships are a constitutional court, my lord, protecting fundamental rights of every citizen. Lord,
This would be a part of fundamental rights of large section of citizens, my lord, in large, my lord, in several states where, my lord, their natural resources, their other resources, my lord, are being shared only on economic grounds.
Now, Mr. Solicitor, let's go rapid fire now on your argument to,
Yes, yes.
your response to constitutional validity.
Yes, yes. Kindly, my
You've
lord.
shown us the statutory scheme, right?
Yes, yes.
Just tell us now what is your answer to the constitutional challenge.
Yes, my lord, please come to, my lord, my written submissions, volume 2A.
Volume 2A.
2A, my lords. And I'll, my lord, as your lordships have said, rapid fire, I'll skip, my lord, what is, they may be treated as read, my lord, but volume 2. Lord, to page 8. I'm skipping, my lord, whatever is not relevant immediately. Lord, enactment of section 6A, the history, the background behind it, my lord. There was a debate in parliament. Your lordships may not get much on that, my lord, except that I'll just, my lord, paraphrase so that your lordships may not have to read. Assam Accord provided and the government has agreed, that is one.
Number two, at the relevant point of time, the war. And therefore, people have come. And most important, my lord, your lordships would get at page 10, because there was an argument of Article 11, my lord, that this amendment is virtually amending Article 4 and 5. Lord, that was 4, 5 and 6, I'm sorry, 5 and 6. Lord, that was, my lord, dealt with when 6A was being framed by the then Home Minister, my lord. Please see, my lord, page 9, Shri S.B. Chavan, the then Home Minister. Page 10, my lord. Page 10.
Your lordship gets, my lord Justice. I am also referring to Article 11 of the Constitution, which clearly lays down that government is within its own powers to enact legislation conferring or terminating the citizenship, any of the rights which a citizen can possibly have. So this is a very wide power which has been provided for. There is no question of any infirmity under the Constitution
or any other law for the time being in force. My lord, then your lordships can skip the rest.
And come to, my lord, page
Just
11.
that little part, PDF 2, of that part in the middle, we have made a commitment.
Yes, my lord, that's what I said.
That is a little important because
We
you
have
said-
made a commitment to stop a large number of infiltrators who have been crossing over. The average rate comes to about 2,400 per month. All these people have been trying to cross,
And we have been trying to push them across the border. There is no denying the fact that the people have come. Whatever Bangladesh government might say, I can say without any fear of contradiction that in fact, a large number of people have come. But they had come in a very peculiar circumstances, and that is why we could not possibly afford to take very harsh attitude, and that is why conciliatory attitude had to be taken, and that is why legislation is there. Lord, it says about post, pre-71, but admitting the position that this position has continued even after 71.
What was the statement of objects and reasons of the bill introducing section 6A? What did the statement of objects and reasons say?
my lord, to give effect to the Assam Accord. I tried,
That's all.
but my lord, your lordship did
Nothing
not
beyond
get any
that.
assistance from that. My lord. Therefore, my lord, we tried and searched the debates of Parliament. Then, my lord, at the foot of page 10, the bold part, Shri Bhadra Pratap Singh, this unprecedented situation was not contemplated by 1955 Act. Therefore, this present amendment is trying to solve that situation, and Parliament is competent under Article 11 to enact this kind of a legislation. Then, my lord, Mr. P.A. Sangma's, my lord, is relevant at page 11. He was, my lord, MOS in Department of States. Members from this side and the other side, including, I think, Mr. Babul Reddy himself, have pointed out that Parliament is competent to decide on all matters relating to citizenship. And this has been very clearly, very expressly, unambiguously put forward in Article 11 of the Constitution. Therefore, the constitutionality of this bill cannot be doubted. The power of Parliament to enact such a bill cannot be challenged at all. My lord, on 11, let me, my lord, complete my submissions in 5 minutes. My lord, A. And my lord, there is a interesting Constituent Assembly debates when 11 was being framed.
Yes.
They say that we have to leave it to the Parliament. How? My lord, Article 4, Article
Why don't you
5 and
formulate it A, B,
it is
C?
there, it is there. But, my lord, I'll just orally point out and then, my lord, show your lordships. Lord, Article 5 and 6 talks of deemed citizenship. That if you are born or if you have come before a particular date, Article 6 and 7.
6 and 7.
6 and 7, I stand corrected. Then you are deemed to be a citizen of India.
Yes.
That was when the Constitution was framed. Subsequent to the Constitution, there may be situations where the nation needs to confer citizenship on various other grounds or take away somebody's citizenship on certain grounds, and therefore Article 11.
Acquisition and termination.
Yes. So 6 and 7 are deemed citizenship when Constitution came.
11 is for future contingencies. Second, and my lord, this is on textual reading only. If 6 and 7 were to be frozen in time, as argued by the petitioner, then why have 11 at all? Then 6 and 7 is complete code. There cannot be any additional reasons for conferment of citizenship, or there is no provision for taking away citizenship.
Which their answer would be that Article 6 and 7 is Pakistan specific. That it basically deals only with Pakistan, right?
Correct, my lord.
So the purpose of 11 is broader. 11 covers, but it will, Article 11 would not cover only Pakistan. It will cover the entirety of the...
Entirety of the world. Well, there may be several citizens. For example, my lord,
The argument was that once, which you have to deal with, which is that once the date of 19 July 1948 is chosen in Article 6 for the conferment of deemed citizenship, then the argument was that you can't, by the exercise of an ordinary legislative power, reach that date of 19th of July 1948 because Bangladesh, 25 March 1971 and prior thereto, Bangladesh is a part of Pakistan. The area of Bangladesh now, specified territory is a part of Pakistan. LBT is Pakistan. Now, therefore, the argument is that you can't, in respect of a period covered when the specified territory was in fact a part of Pakistan, can't confer by deeming citizenship by deeming an act of citizenship, because 6A also is deeming
Confer but
citizenship.
not deemed.
You can't, yes, you can't, because you are making a deeming fiction. And that deeming fiction can't transgress the limitation which has been prescribed in Article 6. That's the argument.
Answer your lordships would get from the Constituent Assembly debates, which I have quoted, relevant part of only
Where is that?
Article 11.
Because, Lord, the theme is
वो बंद कर दें उसमें
they won't send to us. Why should they?
to that, one answer to that which we put to them was that Article 6 deals with the position as of the date of the adoption of the Constitution.
That's
It
what,
basically dealt with the historical context of partition. Article 6, the answer probably would be that Article 6 does not tie down the hands of a future parliament to decide to
the
confer
contingency is not
in
contemplated.
Article 6.
Article 6 can't be regarded as an exhaustive universe.
The
That would be the simple answer, I think.
So your lordships would see Article 6, they say at the commencement of the Constitution. So, and they say very categorically while drafting the Constitution, while Article 11, that we may not be able to conceive of situations which might arise in future.
It's a declaration of citizenship for a group of people under the Constitution, that's
At
all.
that point of
That's all,
time,
that's
under
all.
those circumstances.
To accept their argument would mean that Article 11, the ambit would be to all countries other than Pakistan.
Yes.
Because that would be perhaps a very narrow reading of the power which is conferred by Parliament. Article.
Another thing, Lord, apart from the fact that Article 11 starts with nothing in the foregoing provisions,
It's a non-obstante clause.
but initially when it was introduced as a draft, it said further provision governing citizenship, which was deleted consciously. But just give me 5-10 minutes. Can I please come to page 12, 14 of my written submission.
13 starts with drafting history of part 2, entire part 2, but we are more concerned with Article 11. Lord, para 37. Does your lordships get me? 37. On 29th April 47, while moving clause 3, Sardar Patel requested that the following should be added to clause 3, thereby empowering the union. Further provision governing union citizenship may be made by laws of the nation.
This was, my lord, the beginning of Article 11. This was conceived by Sardar Patel, my lords. My lord, thereafter, your lordships may, my lord, directly come to.
It was referred to a committee. Please come to para 44. And the redrafted clause by the committee is, my lord, at para 44. It went before 3 different committees, my lord, this Article 11 issue. Thereafter, Sri B.N.
The
Rao,
constitution of the committee, it had Vardacharya,
my lord, all were eminent, my lord, please see.
Mr. Alladi Krishna, Alladi Krishna,
Kanayalal Munshi, K.N.
K.N.
Kaju,
Kashu, Munshi and
Munshi
Dr.
and Dr. Ambedkar himself. We were fortunate to have, my lord, this constitution because of, my lord, people of this eminence and intellect. Then, my lord, what they suggested was every person born in India, in the union and subject to its jurisdiction, every person either of whose parents was at the time of such person's birth a citizen of union, and every person naturalized in the union
Shall be a citizen of union. Further provision regarding the acquisition and termination of union citizenship may be made by the law of the nation. Still further word remained, my lord. Thereafter, my lord, it was redrafted, and your lordships would find at page 44, para 3 only, my lord. Further provisions governing the acquisition and termination of union citizenship may be made by union law, that is parliamentary law. Then 45. Meanwhile, the Union and Provincial Constitution Committee at their joint sitting on June 5 appointed a subcommittee to consider in detail the effect of June 3 plan. My lord, that is Mountbatten plan. My lord, it's referred to as June 3 plan. The joint subcommittee met on June 8 and decided that the question of nationality and citizenship in the Union should be re-examined by the ad hoc committee in light of the plan. In the report submitted by the Assembly on July 4, the Union Constitution Committee incorporated the citizenship provisions contained in the memorandum without any change, except that the word union was replaced by the word federation. My lord, your lordships can skip that. And my lord, please see the committee's, my lord, is quoted, my lord. In this connection, my lord, page 16 top. In this connection, the committee quoted with approval the view of Calcutta Law Journal. It is not possible to define exhaustively the conditions of nationality, whether by birth or naturalization, by the Constitution. If certain conditions are laid down by the Constitution, difficulties may arise regarding the interpretation of future legislation which may appear to be contrary to or to depart in any way from them. The exact argument which is made. It would, in our opinion, therefore, be better to specify who would be citizens of Indian Union at the date when the Constitution comes into force, as in the Constitution of the Irish Free State, and leave the law regarding nationality to be provided for by the legislation by the Indian Union in accordance with accepted principles of private international law. But this gave birth to Article 11. But it is now in the evolution process.
Lord, please see para 48. When the draft was presented, but I will not read, there were 140 amendments to the Constitution. Dr. Rajendra Prasad was pleased to say that you have it as a composite thing. Don't go one by one, but not relevant. Please come to para 50. Am I with you?
Yes, sir.
Para 50. The Constituent Assembly debates with regard to citizenship and especially Article 11. Lord, it was draft Article 6. So somewhere there would be a reference of Article 6, but that is present 11. Is illustrative and clearly points towards an overarching power being available to the Parliament. The following are the debates. Dr. Ambedkar, Mr. President, sir, except one other article in the draft Constitution, I do not think that any other article has given the drafting committee such a headache as this particular article. I do not know how many drafts were prepared and how many were destroyed as being inadequate to cover all the cases which it was thought necessary and desirable to cover. It is not the object of this particular article to lay down a permanent law of citizenship for this country. It is very categorical. The business of laying down a permanent law of citizenship has been left to Parliament, and as members will see from the wording of Article 6, which is present earlier, my lord, Avatar of 11, as I have moved, the entire matter regarding citizenship has been left to Parliament to determine by law that it may deem fit. The effect of Article 6 is this, that Parliament may not only take away citizenship from those who are declared to be citizens on the date of commencement of this Constitution by the provisions of Article 5 and those that follow, but Parliament may make altogether a new law embodying new principles. They must not understand that the provisions that we are making for citizenship on the date of commencement of this Constitution are going to be permanent or unalterable. All that we are doing is to decide ad hoc for the time. I don't think with respect there can be anything more clear than this. Then, my lord, next, Dr. Rajendra Prasad, my lord, only highlighted part I may read. I would therefore suggest that amendments of this nature might also be left over to be dealt with by Parliament at a later stage, and we might confine ourselves to the limited question of laying down the qualification of citizenship on the day of Constitution came into force.
As my lord, the Chief Justice, my lord, say.
Then, my lords, your lordships may kindly come to page 19. There are other, my lord, honorable members saying the same thing, but page 19 is Lord Dr. Alladi Krishnan, Sri Alladi Krishna Swami Iyer, my lord, at page 19, my lords.
Yes.
Sri Alladi Krishna Swami Iyer, the articles dealing with citizenship are therefore subject to any future nationality or citizenship law that may be passed by Parliament. Parliament has absolutely a free hand in enacting any law as to nationality or citizenship suited to the conditions of our country. It is not to be imagined that in a constitution dealing with several subjects,
It is possible to deal with all the complicated problems that arise out of citizenship. Then, my lord, Hridaynath Kunzuru also, my lord, only highlighted part. There is nothing permanent about the qualifications laid down in Article 5 to 5C. I'm sorry.
Yes.
5 to 5C. Article 6, that is 11 present, my lord, with slight modification that further becomes, my lord, nothing contained. Article 6 makes it absolutely clear that notwithstanding the provisions of these articles, Parliament will have power to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Any defects that experience may disclose can therefore be easily rectified. The Parliament get experience, they need more qualifications, they need to take away citizenships, not concerned about in this case, but generally.
Yes.
sorry, I did something, yes. Lord, now, my lord, your lordships have, my lord, on the last day when my learned friend was distinguishing the judgment which I was to cite, have seen, my lord, at page 21, on interpretation of Article 11, that is, my lord, Izar Ahmed Khan versus Union of India.
My lord, this is the judgment by 5 honorable judges, my lord. I'll read the highlighted part.
It's, my lord, authored by my Lord Justice Gajendra Khatkar. Lord, at page 21, bottom highlighted part. Article 11 confers and recognizes the power of Parliament to make any provision with respect to not only acquisition but also termination of citizenship, as well as all matters relating to citizenship. Thus, it would be open to the Parliament to affect the rights of citizenship and provisions made by the parliamentary statute in that behalf cannot be impeached on the ground that they are inconsistent with provisions contained in Article 5 to 10 of Part 11. Part 2. So clear that 11 is an independent power and it can add to.
Let's read the next sentence also. In this connection.
Yes, I'll just, my apologies. In this connection, 246, it is important to bear in mind that Article 11 has been included in Part 2 in order to make it clear that the sovereign right of Parliament to deal with citizenship and all questions connected with it is not impaired by the rest of the provisions of the state part. Therefore, the sovereign legislative competence of the Parliament to deal with the topic of citizenship, which is part of entry 17 list 1 of the 7th schedule, is very wide and not fettered by the provisions of Article 5 to 10 of Part 2 of the Constitution. This aspect of the matter may have relevance in dealing with the contention raised by the petitioners that their right under Article 19 are affected by the impugned provisions, etc. So, my lord, this is the only judgment, my lord, on Article 11, but even textually and keeping in mind the drafting history, the only